So good afternoon, and thank you for joining us after a very brief short break. We are starting panel 3, which title is Harm Caused to the Community as a Whole, Dissecting Various Objectives and Respective Changes in the Practices. The objective of the panel is to look at the various objectives of international criminal justice and international criminal law to analyze which ones are contested, uncontested in the common fight against impunity. It is our great pleasure to invite and to welcome 3 experts who will provide a brief presentation on the topics raised and then have an interactive panel discussion on reflections and dissecting the various objectives and bringing them with a practical recommendation on the way forward. We have today with us Dr. Brian McGonigal-Lai, who is an associate professor with the Netherlands Institute of Human Rights and Montaigne Center on Rule of Law at the Utrecht University School of Law. She's also a senior legal advisor with Public International Law and Policy Group, and her specialization includes human rights, transitional justice, victims' rights, documentation and accountability for serious human rights violations. We also have with us today Sarah Kasande, who is the head of the office of the International Center for Transitional Justice in Uganda. She is advocate of the Court of Judicature of Uganda and a transitional justice expert with over 12 years of experience, having provided technical expertise in diverse African contexts, including Uganda, South Sudan, Gambia, Tunisia, and Kenya. Before joining the ICTJ, Ms. Kasande was Senior Program Officer with the Ugandan Association of Women Lawyers, and she's a co-founder and board member of a Chapter 4, a human rights organization dedicated to protecting civil liberties and promoting human rights for all in Uganda. Last but certainly not the least, we have also Ms. Karen Mosoti, who is the head of the liaison office of the International Criminal Court to the United Nations in New York. Prior to this, she was a career diplomat serving her country, Kenya, in various capacities, including as senior state counsel and legal advisor to the permanent mission of Kenya to the United Nations, advisor on human rights, international humanitarian law, and international criminal justice. Welcome all of you, and thank you very much for joining us today. The questions that we have set out for this panel are following. I will read them out all 3 in one go, and then I will give a floor to Professor Lai. So the first question that we have set for the panel is, what is the ultimate objective of ICL? And whether there is one ultimate objective. The second question is, what are the challenges to the objective setting that are being brought by the wider discussion on international criminal justice and potentially international transitional justice or transitional justice? And the last one is, what are the other or potentially correlated challenges in implementation of the existing legal framework? We will try to address these questions within the 5 to 10 minutes framework, and then we'll try to do a follow-up interactive panel discussion. So without any further ado, and considering that we are short on time, I give the floor to Brian.
Thank you so much, Yolana. So, is there an ultimate objective of international criminal law? Yes, in my view, there is an ultimate objective, and that is to contribute to ending impunity for serious international crimes. More specifically, for traditional international criminal law infrastructures, it is to investigate and to prosecute individuals suspected of committing serious international crimes. But while there may be primary or an ultimate objective, it is certainly not the exclusive objective. And as we heard in the previous panel, there are a number of other objectives that have been articulated by the various courts. These range from prevention or suppression of crime, contributing to a historical record, norm development, promoting the rule of law and fair trial processes, and of course, justice for victims. But as noted by Payam, what about capacity building? If states are primarily responsible for prosecuting these crimes, should this also not be a key objective? And what about restorative justice goals and the various justice systems falling under international criminal law? Is this not also connected to broader issues of justice for victims? These have been less visible What is interesting is how the various articulated objectives have differed between the various courts and how they've changed over time. At the ICC, for example, at the ICTY, for example, that tribunal had at one time clearly stated on its website that one of its objectives was to contribute to building a historical record. And over time, we see that the various institutions have been walking back on that objective as overly ambitious or perhaps even as problematic. Nevertheless, I do think that the ICTY has met this objective, largely through its impressive archives, if not through its judgments directly. At the ICC, if we take a look at its preamble and on its website, we see a strong emphasis on ending impunity, of course, but also on justice for victims. But what exactly is justice for victims? Is it securing a conviction? Is it participating in the proceedings? Is it obtaining reparations? Or is it something more fundamental than that? Is it a change in circumstances that gave rise to the violations in the first place? Despite their important successes, and these should not be downplayed, I would agree with Judge Joanna Corner that international criminal law as a field has struggled in many ways to deliver on all of these articulated goals. This is especially the case when it comes to certain rights of the accused or delivering justice for victims, as well as communicating its limitations to communities affected by the crimes. Now, before my 5 minutes are up, I do want to touch on the new developments in international criminal law, which Klaus Kress also discussed in his opening statement, with regards to the increase in universal jurisdiction cases across Europe. International law recognizes that the future of international criminal justice should be domestic. Calls for increased domestic prosecutions have resulted in exciting and innovative legal developments taking shape at the UN, state, and civil society levels. From private investigations carried out by civil society organizations to joint investigation teams and universal jurisdiction cases, and the creation of new UN investigative bodies mandated to help build criminal case files. There is now a move away in many respects from traditional international criminal law infrastructures to a transnational networked approach. And these networks of collaboration between the UN, state, and civil society actors are one of the most important and dynamic aspects of international criminal justice today. These collaborations are defined by their complex relationships, competing interests, overlapping jurisdictions, and extreme urgency and importance. And it's this paradigm shift that signals a new era in our field, which hopefully will bring about increased prosecutions. So the ultimate objective of ending impunity does not change as such, but there are questions around what these developments may mean. So with a few exceptions, there's a clear European dominance in this universal jurisdiction. Will we see a narrowing of the objectives, for instance? If we look at the proceedings in Germany and the Netherlands and Switzerland, the proceedings are not transcribed. For a scholar, this is hugely problematic. Will this impact contributions to a historical record? If there's no outreach to victim communities or voice given to victims in the proceedings, is there going to be justice for victims as an objective? So while promising, this European dominance is also problematic for the global endeavor of ending impunity if states outside of Europe do not also take up the challenge of prosecuting serious international crimes cases. And I think I will leave it there. Thank you.
Thank you very much. Sarah, could you follow up on the wider objectives and the potential contested and uncontested ones?
Thank you, Yolana, and good morning, good afternoon. It's a pleasure to participate in this discussion. And Brianna has done a good job of outlining the ultimate objective of international criminal law. And as we have seen following the adoption of the Rome Statute of the International Criminal Court, we've seen an expansion of these objectives to include restorative aspects, particularly by allowing victims to participate in judicial proceedings and also to apply for reparations, thus bringing the retributive and restorative justice elements closer together. And I think this is one of the critical added values of the Rome Statute of the International Criminal Court. However, there are other wider objectives. Some have already been addressed by the previous panels, which include deterring future crime and promoting lasting peace, delivering justice to victims, strengthening respect for norms of international law, and in particular international human rights and humanitarian law, and establishing a historical record. As we've seen, the Rome Statute system has changed the way the world looks at grave crimes and international law, and has promoted a culture of accountability. Following the adoption of the Rome Statute, a number of national jurisdictions have simultaneously taken steps to domesticate the Rome Statute to provide for accountability for international crimes in their national jurisdictions. In that sense, the Rome Statute has had a positive downstream effect on national jurisdictions through norm setting and norm transfer. We now see more jurisdictions, particularly common law countries, for example, my own country, Uganda, incorporating aspects of victim participation in criminal proceedings, which is something for practitioners in common law jurisdictions, which is something still alien and difficult to fathom. We see greater emphasis on fair trial considerations, and most notably, an improved form of investigating and prosecuting crimes of a sexual nature. However, it's not all been rosy when it comes to the domestication and the establishment of accountability mechanisms in national jurisdictions. This has not often translated into effective domestic accountability, often due to lack of political will and heightened opposition from powerful domestic interest groups, especially security forces, for instance, in Uganda, the Uganda People's Defense Forces, the government, which has particularly objected to prosecution of state actors that are culpable for international crimes. Now, we've set out some of these objectives, and a number of them are quite broad. However, I'll just set out a few challenges in meeting some of these objectives, as witnessed in a number of contexts. And some of these have already been discussed in previous panels. First is that international criminal justice takes place within a highly political context, which may advance or undermine the quest to end impunity. In most cases, mass atrocities occur in contexts where perpetrators still wield significant political power and can leverage their political influence to constrain domestic or international accountability efforts. We saw in the Kenyan cases, for example, how the political actors, the indictees, were able to mobilize the regional bloc, the African Union, but also domestic actors to try and evade accountability. We've also seen, for example, currently in South Sudan, where efforts to establish a hybrid court as agreed under the revitalized agreement to establish as among the Chapter 5 accountability mechanisms, but this is one of those elements that the government of South Sudan has imposed particular difficulty in establishing this. So we see that at times political dynamics affect how international justice is able to achieve its objectives. The other aspect is that although it is reasoned that crimes are committed by individuals, personal culpability and international criminal law is ill-equipped to conceptualize the structural and systemic nature of atrocities. In multiple contexts, acts of violence committed by individuals do not occur in a vacuum. They stem from a culture of authoritarianism, political disfranchisement, acute inequality, and exclusion. Therefore, to end impunity and prevent future violence will require tackling the structural and systematic causes of violence through reforms of laws and institutions, in addition to accountability of particular perpetrators. We also see that, and Brianna touched on this, the aspect of justice. What does justice mean for victims? Justice is often shaped by contextual and cultural realities. For example, justice to some victims entails repairing the harms they suffered through reparations, entails recognition, also entails addressing historical injustices and structural inequality. Therefore, retributive justice alone will not meet these objectives. The previous panel spoke about balance. How do we balance the goals of accountability, but also the goals of delivering justice, holistic justice to victims? And I think this is important, especially drawing from the example of the Hissène Habré case, where Habre was successfully prosecuted and convicted, but unfortunately to date, his victims are yet to get justice. So I'll leave it at that because of the 5 minutes. I believe they're running out, and I look forward to the discussion. Thank you.
Thank you very much. Karen, the floor is yours.
Thank you, Jolana, and thank you to the Nuremberg Academy for inviting me to share my thoughts on this forum today. And also many thanks to my fellow panelists, Brianna and Sarah. I'm privileged to be part of this all-female panel. And I'm happy to be here today. So I have 5 minutes, and one of the challenges of being the last speaker on a panel is that you risk repeating everything that has already been said because the previous panelists have been so eloquent. It's only morning in New York, so I didn't have the chance to listen to the earlier panels, but I'm sure some of the issues have also been covered. So what I'm going to do right now, the objectives and challenges have already been covered comprehensively by Brian and Sarah. So what I'm going to focus on is some of the challenges that we as practitioners face in trying to implement the objectives that were set by the current international criminal justice regime. And for me, I'm focusing mostly on the Rome Statute of the ICC, since that's my area of practice. So, and I'm going to focus on 3 challenges that I see to be at the center of really like the key challenges that we face today in terms of implementing or ensuring that victims get justice. And so I'm just going to briefly talk about cooperation, universality, and complementarity. I know they have already been mentioned. Sarah just talked about, domestic judicial system, so that's part of the complementarity. But I'm going to look at it from the perspective of gaps in the existing legal framework, whether these are gaps in the statute itself, or whether these are procedural gaps that could be filled in using other subsidiary procedures and not necessarily amending the Rome statute. So the first challenge that I cover is cooperation. And cooperation is really a big challenge to ICC, and even before ICC, to the other ad hoc tribunals. The way the legal system is set up in the Rome statute is that the power to enforce lies with member states. The courts themselves do not have the power to enforce their own decisions or to enforce compliance by states who have the obligation to cooperate. So this makes it very challenging for the courts to implement their decisions. And we have seen this play out with the ICC several times. In the situation of the UN Security Council, we have seen judges communicate to the Security Council on more than 10 occasions the lack of cooperation from certain states. And due to the deadlock in the Security Council, nothing has been able. The Security Council is not able to provide a remedy for that lack of cooperation. We have also seen within the context of the ICC Assembly of States Parties where the court has referred situation of non-cooperation to the Assembly of States Parties. And the Assembly of States Parties, as it stands today, does not have a strong enforcement mechanism that can ensure that states that have an obligation to cooperate can really cooperate with the court. And that gap, I would say it largely emanates from the Rome Statute itself. While it provides that cases of non-cooperation can be referred to the Assembly of States Parties and the UN Security Council in the instance where cases are referred by the UN Security Council, it does not specify what remedy is available in such cases. And this makes it incumbent upon states parties, in my opinion, to come up with an effective framework for ensuring that there is at least some kind of consequence for non-cooperation, whether it's non-cooperation with decisions of the court, or whether it's non-cooperation by states who basically refuse to cooperate with the court for one reason or the other. And in previous sessions of the Assembly of States Parties, I know that civil society has been very active on this subject. They have proposed that the Assembly of States Parties could look into establishing adopting a resolution or some kind of mechanism that can deal with non-cooperation. That has not happened, but that is something that can be done just by changing the procedures through a resolution of the Assembly of States Parties without necessarily amending the Rome Statute. And I believe that unless there is an effective mechanism for enforcing the decisions of the court or for enforcing compliance by states parties, I think it's going to be increasingly difficult for the court and other international tribunals to achieve the objectives that have been set out, the objectives that Brian set out in her presentation. There are many objectives. The victims have expectations, but those expectations cannot be fulfilled unless the cooperation framework works. And the second challenge that I will deal with is universality. The thing with universality, I think the problem doesn't lie in the legal framework. The problem is more in implementation, the practice of how we go about ensuring universality and ensuring that there is broad geographical reach for justice, whether states are parties to the Rome Statute or not. So because of this gap, ICC only has jurisdiction in the states parties that have ratified the Rome Statute. It has no jurisdiction in about 1/3 of UN member states that have opted not to join the Rome Statute. And this leaves a gap which in some instances might be filled by the UN Security Council through referrals, which they have done previously in the situation with Sudan and Libya. But again, with the current deadlock in the Security Council, it does not seem that referring another case to the ICC or establishing another ad hoc tribunal is likely to happen anytime soon. So what do we do with this large geographical area that is not covered by any form of international criminal justice? And the solution there, in my opinion, really lies in persuasive strategies by the supporters of the international criminal justice. The supporters just have to come out with strategies that can persuade the people who are still outside the framework to join the framework. That's the only way we can ensure that victims from those areas that are not covered get justice that they deserve. I know that in the recent past, there have been some innovative mechanisms within the UN General Assembly that has established some investigative mechanisms in respect of Myanmar, for instance, and Syria. But again, these are not tribunals. It's like a stopgap measure whereby, the international community is just trying to put together, to collect and preserve the evidence for possible future prosecution with no guarantee that the future prosecution will ever occur. So this is a huge problem that I think states parties, the international community more broadly, and civil society need to be creative about how to bring everybody into the fold of international criminal justice. As long as many areas remain outside this framework, we cannot say that we are achieving justice for victims. We are only achieving partial justice for partial victims. Justice is not reaching everyone. And lastly, I know my time is up, just on complementarity. I will not delve deep into this because Sarah just mentioned giving the example of Uganda. The challenge with complementarity is it goes back to the test of being able or willing, For states to be able to implement or to prosecute international crimes, they have to have the ability, the capacity to do so. They have to have the technical know-how, the resources, and other support systems that they need to be able to implement this. And in the absence of that, complementarity remains a pipe dream. It's there, it's a primary responsibility of states to investigate and prosecute, but they can't do it if they don't have the capacity to do it. And that's the ability test. But the second challenge to complementarity is the unwilling test, which goes back again to the question that has been mentioned by previous panelists, the question of political will. And political will for me is one of those overarching challenges that, kind of hovers above everything else, whether we are talking universality, whether we are talking cooperation. In the absence of political will, we cannot achieve any of those. And this is a big challenge because political will cannot be forced. It really depends on the goodwill of individual states to commit, to be principled about their support for international criminal justice. And until that happens, it's very challenging for international criminal tribunals to achieve their objectives, and especially since they depend on states, on political actors to be able to enforce their decisions and to provide the support needed to do the investigations. So I think with that, let me end there, and maybe I could say more during the discussion. Thank you very much. Back to you, Jelena.
Thank you. Thank you very much. I think we all have scrambled quite a lot of notes. So I think it's just fair that I give a round, like a 2-minute presentation reflection to each one of you, because you all covered different aspects of objectives, implementation into a legal framework, which I think is going to be interesting then to reflect at the end in terms of way forward, and really then dissect it when you're referring to the objective and then the implementation of the framework. And I like the distinction between the two to really make it more focused. So I'll start with Brian.
Yes, thank you. Yeah, I was also one of those people scribbling lots of notes. And yeah, I mean, I think one thing, it's really important to place the objectives of international criminal law within the broader picture of objectives of peace building more generally, because as has been said in all the previous panels, international criminal law is just one small part of a larger puzzle when it comes to ending impunity, bringing justice to victims, etc. So one way maybe to also fill those gaps that Karen mentioned is to really strengthen the documentation efforts of civil society organizations. So civil society organizations have long been involved with monitoring and documenting rights violations. But what we've seen in the last 5 to 8 years is that they've really embraced the technological turns that we've all been encountering in our daily lives, and using technology to increase documentation efforts, to increase verification, to increase professionalization and standard practices, capacity building. And it's those documentation efforts when we can ensure that information is secure and safe, that even if we don't have a justice process now in certain countries or situations, it means we won't lose a lot of the information and potential evidence that can be used later. And we can look at situations around the world where we see a delay of international or domestic criminal accountability. If we look to situations like Argentina being one of the best examples for that. So I think one of the gap fillers I would add to Karen's comments would be increased support for civil society documentation efforts. I would also, as a gap filler, encourage states to look at the draft convention on crimes against humanity and the need to have that ratified, or to move forward first with the process and hopefully lead to the convention, and also the draft treaty on mutual legal assistance. I think this touches again on a lot of the points that Sarah and Karen mentioned when it comes to cooperation efforts. So that would be my reflections.
Thank you very much. Sarah, would you like to reflect as well?
Yes, I think there are lessons that can be drawn from different jurisdictions as well that I think are key. And in this sense, looking at regional responses, what are some of those regional responses to international crimes that could offer examples or could offer lessons for other contexts in terms of promoting accountability, especially where we see, for instance, domestic jurisdictions are really equipped, but also the International Criminal Court or hybrid courts are also incapacitated to fulfill this mandate. And I would like to draw attention to, for instance, the proposed expansion of the African Court on Human and People's Rights to grant it criminal jurisdiction. I believe there are lessons from the Hissène Habré trial in the Extraordinary African Chambers. There are often opportunity for this particular court, if the jurisdiction is granted, if states ratify, to close that impunity gap and see how it could also contribute to addressing impunity. But also, as noted before, ending impunity or goals of international justice must be seen within a broader and systemic long-term manner, looking at other transitional justice approaches, be it truth-seeking or reforms that tackle those structural and systemic causes of violence. As noted previously, we've seen in many contexts where the ICC has intervened, a recurrence of violence, a recurrence of conflict. So unless the root causes of these conflicts or violence are tackled, then it will be difficult to achieve the ultimate goal of ending impunity. Therefore, international criminal justice must be complemented by specific and targeted reforms, reforming power structures, reforming institutions that are behind violence. Thank you.
Thank you. And Karen, any reflections on the additional comments so far?
Yeah, thank you, Yolana. Let me just pick up on where Sarah left and just talk about, maybe reflect a little bit more on the role of regional institutions such as the African Union. In the context of filling in some of the gaps that we see, whether in the legal framework, the architecture of the system, or in the procedural framework. And Sarah mentioned the initiatives by the African Union, and I remember the Malabar Protocol and the environment that surrounded the drafting of this protocol. This basically happened at the height of tensions between the African Union and ICC, because that's when, you know, the Kenyan cases, the case against Bashir in Sudan were ongoing. So it was really a very tense time. And I think the protocol itself, even the initiative to have that protocol within the African region is a positive step that should be lauded. I think it's a significant progress. It's unfortunate that immediately after it was adopted and somehow the proceedings against the Kenyan cases were terminated, the appetite to push forward with the protocol somehow dissipated. And at least as far as I know, there hasn't been a single ratification. I'm not sure why. I'm not sure whether there is an effort in the region to try and encourage ratifications. I don't hear much about the Malabar Protocol anymore, but definitely it's something that could be used at regional level to fill the complementarity gap, in the sense that if we have a functioning judicial system, either national or regional, this is something that could also address the impunity gap in the areas where ICC is not able to reach. And I really hope that this is something that regions, not just the African region, other regions can also, think of, regional mechanisms that can support the fight against impunity. But apart from the possible complementarity role that regional groups can play, I think regional groups can also play a major part in filling the gap in cooperation. And unfortunately, in the context of the African Union, they were playing, in respect of the African cases before the ICC, they were playing the opposite of supporting cooperation. They were basically taking decisions not to cooperate with the court. And I think it's time for regional groups to also reflect on whether, if they really support international criminal justice, whether they should be taking decisions that aim to undermine the system rather than taking decisions that actually complement the system. So, and in addition to that, regional groups could also play a role in just encouraging universality, in the sense that, sometimes peer pressure works. Peers tend to listen to people, people who are, with whom they share the same context. And this is key in regional groups in terms of encouraging states within a particular region who have not joined the Rome Statute to be able to join. So regional groups could also play a very constructive role in ensuring universality. So I think for all the gaps that we've discussed today, I think regional groups can play a key role. The EU has done it before in respect of the ICTY. They played a key role in putting pressure to cooperate with the ICTY. I think it can be done in other regions as well. I think this is something that, we should think about developing further and seeing how this could be replicated in other regions as well. Back to you, Jelena.
Thank you very much. I know that we were supposed to look at the forward recommendations and key practices, but my question to you is, we've talked about various objectives. We highlighted the various objectives in terms of overarching goals and implementation in various systems, either international criminal law or then wider discussion on criminal justice. And my question to you would be, whether you could provide us with examples of potentially conflicting objectives through the practice that you have seen, and explain how do you see this potential conflict itself being or coming into place. And then the last question would be, and maybe we can combine it because we are a bit brief on the time, would be also looking at the recommendations forward from discussing the challenges and the rising challenges that also Brian mentioned in terms of a changing landscape and changing discussions as such. And I'll start with Brian first, and then we'll continue the circle. Thank you.
Yes, thank you. So I will get into that, what you just asked, but I do first really want to say about the proposed African criminal chamber. On the one hand, I think it's really, really exciting in the sense that the proposed crimes, the subject matter jurisdiction that would potentially fall under it, was expanded well beyond the core crimes. And certainly those working on environmental justice issues, we're happy to see that it included illegal exploitation of natural resources or something along those lines. And but on the other hand, I think there is a worrying impact of the fact that African leaders had gotten together and said that they would be immune from prosecutions. And I think in that sense, we need to see some reservations about developments going along those lines. But again, the ratifications are stalled, et cetera. But I do think while on the one hand, there's very exciting things happening, there's also some worrying events around that regional development as well. In terms of conflicting norms, I mean, the most hotly debated and well-known is certainly the peace first justice debate. And when should criminal prosecutions move forward? Within scholarly literature, there's been a lot written on sequencing of different transitional justice responses, focusing first and foremost on security, and then looking to ways to bring in truth-telling, and then the more criminal accountability efforts, and perhaps, having to delay. But like I said, again, so long as those documentation efforts are supported and really brought up to certain standards, then I think that sequencing can work, certainly. And I see I'm going to leave I don't want to take up too much time, so I'll leave that there.
Thank you, Sarah.
Thank you. I just wanted to highlight one aspect about the AU in terms of its African Union Transitional Justice Policy Framework, which tries to bring together these various elements of looking at accountability, but also restorative justice, and also tackling historical drivers of violence across the continent. And I believe this is a very useful pathway for state parties to the African Union to domesticate some of these norms and to see how various approaches contribute to accountability, but also contribute to prevention of violence and cycles of conflict, and obviously tackle these structural inequalities and other drivers of violence. With that said, some of the competing norms I'd like to say, and some that has been mentioned briefly here, is the court's role in establishing a historical record. We have seen that indeed it has that particular role, especially through particular procedures in which in situations, in contexts where there are contested narratives about what has happened, the court has a role to bring about this objective fact through its fact-finding mission, the objective truth. But we also understand that this is within a very narrow framework with looking at establishing the guilt and innocence of the accused. And even with victim participation, there's still very limited voice of victims in these proceedings. However, with that said, where we increasingly see selective prosecutions, we also see a skewed perspective, a skewed historical record that is created by trials. And in my context, Uganda as well as an example, where we've seen whether at the national or international level, trials have focused particularly on the Lord's Resistance Army. So even if the court is to establish a historical record about the conflict, it shall predominantly focus on the role or crimes committed by the LRA and not necessarily those by the state parties. So I think it does have a role to play, but I don't think establishing a historical record is a primary objective or should be a primary objective of the International Criminal Court. Thank you. I'll leave it at that.
Aaron, please, if you have any reflections, now it's the time.
Yes, I'm just, in terms of conflicting goals and objectives, I wouldn't really say this is conflicting. I think I would say maybe it's more of competing objectives. And this is in relation to, I would say, the deterrent, the goal of deterring future crimes, which many of the tribunals focus on, versus achieving reparations for victims, or rather, achieving reparations for victims. And I say these are competing. Both goals are somehow, the aim of international criminal justice is to ensure that, these tribunals can handle both, and of course, can achieve all the other objectives at the same time. But the challenge is that the way, for instance, the Rome Statute is set up, whereby prosecution focuses on primarily leadership crimes, leadership crimes, the most responsible, who are usually most often the leaders. It begs the question, and many have criticized that aspect, saying that, by focusing just on leaders, you're really not achieving justice for victims. The leaders usually are not direct perpetrators. It's usually people below them who are actually on the ground committing these crimes. It's not the leaders who are committing the murders. It's people at low level who are committing these crimes. And in the absence of complementarity, especially, I think some have questioned whether this is really the way international criminal law should be set up. And of course, there are good reasons why this is set up. I mean, these tribunals do not operate in unlimited resources. They don't have the capacity to investigate, a large number of cases at the same time. So complementarity should fill in the gap. But until that gap is filled in, this will always be an issue. Should we focus on the leadership? Does this really have an impact on the victims? Do victims at the end of the day feel that they got the justice they deserve if the focus is just on the leadership and not the low-level perpetrators? So that's an issue to think about. It doesn't really conflict with the rights of victims. It's just that the focus makes it difficult for some victims to feel that justice is actually reaching them, is trickling down to the victim at the victim level. I know there are reparation programs in place under the Rome Statute, And these, of course, try to reach out to the affected communities, and victims participate in the proceedings. And as I would say, a small number, because the context of this conflict is such that there is so much crime, it's mass atrocities, so many people are affected, and even when victims participate in the proceedings, it's only a small representation of the actual victims. So I think this kind of creates a problem, a balance. It's more of a balancing problems. How do we make sure the victims are satisfied with the justice we offer when we are only limiting the efforts of international tribunals to a small number of leaders who are responsible for these crimes? Back to you, Jolana.
Thank you very much. All fascinating and a lot of follow-up, but we are running out of time. So I will ask the speakers if you are willing to share your outlook or recommendations or suggestions that you see as a way forward in addressing some of them. Please use the public chat so everyone sources from your expertise. Otherwise, we are in this position where we exchange panel 3 to panel 4. And I would like to really wholeheartedly thank panel 3 for joining us today and sharing their expertise. And while we are in a transition, I'll introduce panel 4.